I've been planning a company for 25 years, and I've done thousands of families, thousands of trusts, and I've developed a specialty in working with families who have children with developmental disabilities. A little bit later, I'm going to talk to you about an app I created because we've gotten so deep into this planning, understanding that it requires more than just legal documents and more than just court work and conservatorships, but there's a whole system that we built to support you and your children, your entire family, all to achieve positive outcomes for everybody. So as we learn more about this, I'm excited to share with you all these tools we've learned. We have a purpose of this meeting workshop this morning. We're going to talk about fundamental estate planning tools. We're going to talk about special needs trusts. We're going to discuss conservatorships. Most importantly, we're going to listen to your questions and provide answers. Now, I have an associate, Amber Pearce. She spells her name precisely the same way I do, but we're not related. I like to call her my sister, but she's not really my sister. But her and I are very tuned into our mission in assisting families who have kids with disabilities. So Amber will be on the call in just a few minutes. She had to take care of some, I think, soccer games this morning for her kids, but she'll be logging in about 10 to 15 minutes. And what that does for us, it allows you to post your questions on chat. I'm sure you're all familiar with that. You can post any question. I think Amber will be able to answer those questions in real time. And then what she's going to do is collect some that she thinks might apply to everybody. And I can cover those in the question and answer session. So feel free to use chat and Amber will review those and respond to you. I won't be able to do it because if I start doing that, I'll disrupt the whole workshop. So let's start off with the basics. I'm dedicated to working with families who have kids with special needs. I have a website called pearcelaw.net, and I like to call it my high five website, because the main point I want to make to everybody is when you're talking about trust planning, special needs trust, conservatorships, and transitions to adulthood, there are a lot of obstacles and challenges that you face as families who have children with special needs. But our approach is that we're always on the high five part of that, saying, yeah, there's a solution. We've got an answer. Yes, we can get that stuff done. So we take a positive approach. And if you look at my website, you'll see a page called We Love Special Needs Smiles. You may recognize some of the families there because I have a tradition. This is after a courtroom conservatorship case. We always come out after the conservatorship case and do a high five, big smile case for our families. So, you know, as a general background, I appreciate you taking the time this morning, and I know we're all busy. I've got a pile of yard work to do at home this afternoon too. We get busy with school, taking care of family, children, job, just filing tax returns. Every day there's something to do. And we know that estate planning is important. Special needs trusts are important. All that stuff is important to do. And we're always meaning to get around to it, but somehow it falls to the bottom of the list. And that's true. And I'm not saying there's anything wrong with that. That's just human nature. And I get it. So, but when we don't do planning, certain things are bound to happen. Most people, unfortunately, go forward in life, some tragedy occurs, and there's no real plan, no coherent, thoughtful structure for what happens at the death of a spouse, or gosh forbid, both parents. And most of us end up leaving no guidance whatsoever. When that happens, there are things that are certainly going to happen. There's going to be unnecessary court costs and legal proceedings. There'll be delays and distress for your loved ones, even a spouse. If one spouse has been the primary person handling all of the financial and legal matters, that spouse dies. The other spouse is really left in the dark. And then if both spouses go, we've got a family without any access or control of the resources. Most importantly, for our audience this morning, we are super focused on what happens to needs-based benefits for your child with special needs if you die without a plan. That's the big question. What I mean needs-based is there are benefits that can accrue to your child. Maybe some of you are receiving them now, SSI, Medi-Cal. These are based on financial need. And without a good plan, those benefits can potentially be lost. We can also see inheritances be wasted. So, you have a child with special needs, you have other family members too. But when you die without a plan and your other family members at age 18 or 19 and your other children inherit their money, if there's no plan for it, it can be wasted. And it's not their fault. We can't expect 18-year-olds to know what to do with $500,000. So when good planning is not done, most of what you built over your lifetime can be wasted away quickly and also have adverse impacts on your child with special needs. Now, we don't want that to happen. And of course, I'm not going to emphasize just bad news today. We're going to emphasize solutions and things that work. And that's what we jump to now. If you haven't done good estate planning, we don't want to leave this legacy. A judge delays, costs, distress. So there are solutions for this, and that's what we're going to talk about it. The most important thing to understand is that estate planning can guarantee results. As a planner, I can guarantee results that are absolutely going to happen when you die. We can control what happens after you die to a greater degree of certainty than we can control what you do with your assets this afternoon, because our plans are legally enforceable and we thought through all these problems. And there is a solution for every planning concern. Later, we're going to talk about situations where we're not quite sure who would be our child's guardian. We're not quite sure who would be our trustee. We don't have anybody close by. We don't have any family member or friends that can do that. But we have solutions for these things. The important part of planning is to get into the planning process, identify the problems, and then we can find the appropriate solution. There is always a solution. You can control the future for your family. You can reduce stress, you can minimize costs, and most importantly, you can preserve benefits. The most important thing to understand is that the surprise is it's not that hard to do. And that's what I want to emphasize today. Getting started, I think the hardest part is attending this workshop and making the phone call. Yes, we want to get started. From then on, it just goes very quickly. So good estate planning, what do we mean by that? It's going to give what you want to the people you want, when you want it, and the way you want, with the least possible cost. It's a pretty simple goal stated, but accomplishing that takes some planning. What do you need for an estate plan? And have you noticed I haven't really focused on special needs trust yet? But be patient with me because we'll get to that. But we need to establish a groundwork first. What do we talk about when we start to talk about planning? Because you cannot have a special needs trust without having a basic foundation of your estate plan. It would like trying to build a house without a foundation. We don't want to jump to special needs trust until we got your foundation in place. And they're pretty simple to build. So the question everybody asks me, well, what do I need? Do I need a will or do I need a trust? Okay. And so we're going to talk about each right now. But before we talk about wills or trusts, we want to emphasize again, you need a plan. And the plan may be written in a will, or you may create a plan and a trust. But we need more than that. We need to think through all the things that are unique and specific to your family, because all estate planning is very personal. There's no cookie cutters here. All planning reflects who you are, who you love, everything you own, what you care for, your hopes, dreams, and desires. And that's about as personal as you can get. So we think about those things, and then we say, well, what tools can we use to build them? The goals of your estate plan: organize your assets and benefits, make sure that everything is all together, and so that husband and wife both know where things are, and your successor trustee know where your things are. You want to have a plan that's going to give what you have and the benefits that you provide to the people you want it to go to. And that sounds like, well, isn't it automatic? My kids will get my stuff? Not necessarily. There's a lot of questions they ask to determine how you want them to get it. You want to choose the people who are going to take care of your children: guardians for kids under 18, conservators for a special needs child over 18. And you want to have a plan that's going to protect your children's inheritance, not from the guardians or trustees, but from themselves. Giving a 20-year-old $500,000 in insurance or 401k or equity in a house is not a good plan. Your 20-year-old neurotypical child may be wonderful, maybe at MIT on a full ride scholarship, but handing them $500,000 at age 20 when you're dead is not a good plan. I think overall what we're talking about, and I think why people attend these workshops and come to me, is they say, look, we want to leave a good impression. We want to be responsible people. We love our spouse. We love our children. We want to make sure everything's going to be okay. I want to feel okay about myself. Oh, there's Amber. She just showed up. Okay. And that's what you want to do. And so this would be a good segue. And Amber, you've got perfect timing because we're talking about leaving a good impression. And so I want to take a minute and introduce Amber. And I don't know, Mina, can you spotlight Amber's picture? There she is.
Sure.
Hi, Amber. Welcome.
Hi, good morning.
Everyone, this is Amber Pearce. She's an associate. As you see, we share the same last name, but we're not related except by coincidence and fate. And so that's the best kind sometimes because you can choose your friends, you can't choose your family. And I choose Amber, my friend. Okay. So Amber and I work together on some cases. Sometimes, as you can imagine, I get super swamped. And Amber can step in and handle court proceedings for conservatorships. She's got availability and she's an expert in trust planning. And she's also just a very nice person. Okay. So Amber today is going to field your chat questions, and there may be some coming, and we encourage them. And she'll answer you in real time. She can't give you any specific legal advice about your situation, but she can answer general questions about process, timing, anything that comes up. Feel free to ask, okay? And we like that. So I'll focus on the presentation and Amber will focus on your questions. And what she's going to do is collect a few, 2 or 3 that might apply to everybody. And then we'll go over those at the end of the workshop too. So the first thing I'd like to know from everybody, and you can let Amber know, is am I proceeding at the right pace? Is it too fast, too slow? Let Amber know, and then she'll give me a heads up on how to modify my presentation. But if I go too fast, I'll slow down. But I hopefully will make it simple. So we want to do estate planning. Here's what everybody needs to do. And it's not just a special needs trust. You need to start off with, you need a plan for distributing your estate, whether it be by a will or a living trust. You need a plan. You all each need a power of attorney for financial affairs. Anybody 18 or over is a legal adult, and no one has authority to make financial or legal decisions for you, not even your spouse. So we'll talk about powers of attorney in a few minutes. Everybody needs an advanced healthcare directive. An advanced healthcare directive is a document whereby you appoint somebody to make medical decisions for you. Now, as spouses in California and under federal law, you have that authority, but you need to have a backup too, in case you're both sick or in an auto wreck. Speaking of being sick, I'm going to take a side road for a moment. This has been, Mina, how long ago did we start planning for one of these We Embrace workshops? I think 3 years ago. There were some health issues for both Mina and me, and then COVID hit. So I'm so excited because this is the first workshop we've done post-COVID. So it's been like a 2.5-year gap in communicating with parents about these important topics. And I really miss it. So I'm really excited about being here. And hopefully one of these days, we can get back to the old school way of showing up, maybe having bagels for breakfast and muffins, and doing a live workshop again too on some topic of interest to We Embrace. We're very open to doing that. I kind of miss the human part of human contact, but for now, these virtual meetings work out great. Of course, everybody here wants special needs planning in your estate planning. So let's talk about these fundamental tools, but I need to grab a bottle of water. I'll be right back. As I said, it's been nearly 3 years. I'm a bit rusty on my workshop presentation. So here are the fundamental planning tools that everybody needs to use. The first one is a will or a trust. And there's a big problem, I think we all understand, and that's why you're here. The majority of us don't do this. And when you don't leave a will or a trust, bad things happen. So you got to have at least a will. What is a will? It's a basic planning tool. It's written instructions for what happens to your estate. You've all heard about wills. They're effective on your death. But wills guarantee probate. They work perfectly fine as a legally enforceable method of distributing your estate to your children or your loved ones. But to enforce a will, you've got to go to court. And probate court is the court supervised transfer of assets from deceased people to living. And because the will doesn't change anything, the will just puts in writing on a piece of paper what you want done when you die. To give that piece of paper validity, it has to be filed with the court. The court has to assume jurisdiction of all your assets when you're dead. There's all this stuff going on. And then finally, at the end of the probate, the judge orders the distribution of your assets to your beneficiaries. So that's a court supervised process of distribution of your assets, because dead people don't sign deeds. So if you own a house and your name is on it and you die, your will doesn't change title. The judge has to change title in accordance with your will. Well, that's a hassle and it's expensive. So probate generates executive fees. It can be, thousands or even tens of thousands of dollars. It can take 1 to 2 years to complete. If we complete a probate in 1 to 2 years, we're heroes, because the court process takes forever. And so there's a bigger cost to probate. It's an emotional cost on your beneficiaries. Now, wills work fine, and in some cases we do them. Actually, Amber and I are working with a client. She's doing a will right now because it fits her needs better than a trust. But it's pretty basic. I like to tell people a will is like, I don't know, a Model A car, and it still works fine. You see them on the road sometimes on the weekend. They have these car clubs. They're old-fashioned, and that's kind of the will. The will is the Model A of estate planning. So let's talk about the Tesla of estate planning. The Tesla of estate planning is a revocable living trust. It is the way people do things now, and it's the way of the future. Very few wills. I mean, I see maybe 1 or 2 wills in 2 or 3 years. So the living trust is the tool that everybody uses now. It replaces the will and it contains your distribution plan, but it's a big difference. A revocable trust is a changeable contract you created during your life. If you're single, you do a single trust. If you're married, you do a joint trust. The trust is going to own your property and assets, and all trusts have 3 parties: the trust maker, the trustee, and the beneficiary. So the trust maker is the person who creates the trust. That's you. Lawyers, we draft the trust, but you are the actual creator of the trust. The trustee is the person who manages the trust property, and you appoint yourself as a trustee of your own trust. The beneficiary is the person that you designate in the trust as who has legal right to receive the benefits of the assets you put in the trust. So as a trust maker, you draft a trust, you appoint yourself as trustee, and then you say, as long as I am alive, or as long as we are alive, husband and wife, we are the beneficiaries of these trust assets. We own everything. So while you're alive and not incapacitated, you retain complete control in the role of trust maker, trustee, beneficiary. So you create a trust and you wake up in the morning and there's no difference in your life. You still own everything. So during your lifetime, we transfer your bank accounts, mutual funds, house, change beneficiaries. You won't do any of this on your own. This is the stuff that requires thoughtful planning. But you appoint yourself trustees and your beneficiaries. You wake up in the morning, have your tea or coffee on the patio, and you own everything still. The IRS doesn't recognize the trust while you're alive. There's no legal difference. But when you die, here's the big difference. If your house is titled in the name of your trust and you're the trustee, in your trust agreement, you said that we will be the trustees. But upon my death, I appoint my sister Amber to be the trustee in my place. So now I'm dead. Amber can come in as the trustee, record my death certificate, certify that she's the trustee. She will have complete control over the house, be able to sell it and distribute the money to my kids, or be able to keep the house for my kids in whatever fashion I wrote out in my trust, that she's legally bound to do that. Okay. So now we don't need a judge because your trust owns all your assets. You've designated a successor trustee. And then when you die, your trustee steps in with complete control, but not ownership, control of the assets. And the third party now changes too. Since I'm dead, I'm not the beneficiary. My trust says when I die, the beneficiaries of my trust are my three children, Julie, Tom, and Jane. So Amber, as a successor trustee, steps in and distributes the house to the three children and without any court proceeding. So it works really well. And so when you're gone, the trust is going to contain a plan for your child's inheritance and your child's future. And this is how it connects with special needs in just a few minutes. Again, we haven't talked about special needs planning yet, because surprisingly so, what you're going to learn in a few minutes, special needs planning is not that hard to accomplish as a goal. The hard part is getting your foundation in place first. Putting the special needs trust on top of it becomes a very pleasurable exercise when we move forward. So there are some planning mistakes that people make, and I like to bring them up only because these mistakes can provide a false sense of security and planning. We call it the do-it-yourself type planning, and sometimes do-it-yourself planning is just fine, and we encourage it where it works. You don't always need a lawyer for everything, but a lot of times do-it-yourself planning, while it sounds good and it seems right, can actually be one of the worst things you can do for your loved one or your family. Let's think about the most common one we see, and Amber, she'll tell you about this. Every estate planning attorney has examples of these. Not everybody has a life insurance policy. Some people have it, some people have an annuity. Most people will have an IRA or a 401k plan or the qualified retirement plan or any combination of those things. Each one of those assets has a pay on death beneficiary, which means that when you sign up for the life insurance with State Farm Life Insurance and you take out a life insurance policy, they'll say, who do you want to have get this money when you die? And that's called the beneficiary. And whatever you put on the beneficiary form, the insurance company is legally bound to pay that person. There's no court required. It's just a contract. They say, we'll pay that person, $500,000 when you die. And you die, that person submits the death certificate and gets the $500,000 check. But here's where the planning issues come about, especially when you have a family. I'm assuming everybody on this call has family members. So you're married and you have a life insurance policy and you do the beneficiaries. What we found is there's some potential glitches. Wrong people can get the money. There's outdated beneficiary selections, no control over the money. If you filled out that beneficiary form 20 years ago when you had one child and now you have three, only one child will get the benefits. So we need to have those updated. But the biggest problem is naming current beneficiaries, right? Look at these things. Who are the beneficiaries on these policies and annuities and IRAs that you opened when you went to work? And you maybe you were single and you got married and you never changed it. We see all kinds of things happening. The real question is, where will the money go when you die? And if you name your children as beneficiaries, here is a real common example. Okay, and this is one of the common planning mistakes we see that can be avoided pretty simply. Let's say we have Bob and Marie Sample. They each buy a life insurance policy on each other. If Bob dies, he wants to make sure that Marie's got some money to help her out and vice versa. So the insurance agent says, who do you want to have be the primary beneficiary? And they go, well, of course, our spouse. We want each other to get this money if we die. Well, then if you both die together, like in a car wreck or something like that, who gets the money then? Well, of course, our children get the money. And in this case, they got Julie and Jim. Okay, Julie's 8 and Jim's 4. So what happens in the real world when that real car accident actually happens? And there's neither Bob nor Marie to collect money, and it kicks to the contingent beneficiaries. So State Farm wants to write a check to Julie and Jim, right? So Bob and Marie, like most parents, they did a good job with insurance and they meant well, but they never got around to estate planning. So what happens to the money? Well, the insurance funds, after the accident killed their parents, Julie and Jim need to go down to the bank and establish bank accounts. They need to talk to their financial advisor about saving some of that money for college. They need to start a retirement plan. They need to invest in a diversified portfolio. And so Julie and Jim are talking to their financial advisor, doing all that stuff and collecting the money. And you're saying to yourselves right now, what's Michael talking about? How can an 8-year-old and a 4-year-old open a bank account and deposit the money? Well, you know what? They can't, right? So here's how it really works. For parents who haven't done estate planning and their kids are the contingent beneficiaries on their insurance or IRA or whatever, when they die, there'll have to be a probate proceeding in court called a guardianship. And the court will appoint a legal guardian to assume a responsibility for collecting that money. And that money will be collected by the guardian, put into 2 accounts for Julie and James. And the court's going to say, you hold on to the money, manage it. And then they only get their money when they become adults. So at what age does your child become a legal adult? Right? Think about it. 18, right? Without a plan, what will your son or daughter be legally entitled to have all the money? You're dead. There's $500,000 that's now grown to $750,000. They get that money when they're 18. And your kids may be the exception, but most kids would never be able to withstand the pressure of spending that money. And they'll have lots of friends to help them. So it's party time. So the main rule to remember here is that when we do thoughtful planning, we're thinking about our hearts are in the right place. We want our kids to get this money when we die. That's why we're paying the insurance company for it. That's why we're making this sacrifice. But you got to have a plan for it, because naming that kid as a beneficiary seems like the right thing to do. But you got to remember, your kids are going to grow up one day, right? And you don't know. Some of you may have older kids. Amber, you're not there yet, but we all got news for you. You don't know, right? And so, and maybe this rock and roll star is making millions of dollars on Spotify. We don't know. But assuming that everything's going to be fine if you leave your kids money isn't really the plan, isn't really the solution. You need a plan for that. So with beneficiary designations, especially for insurance and things like that, which is typically an IRA, 401k insurance, or a major portion of your estate, you need to be thinking about what will happen to that money when you die. And that's where a living trust can help you. Because in your living trust, remember, I'm dead. I've got 3 kids. I've appointed my sister Amber as trustee to hold on to money for them. And instead of saying just giving them money when they're 18, help them with the money under the terms of the trust, car, school, wedding, and then distribute it slowly. Give them 25% at age 25, half at age 30, and the rest at 35. And if they're doing okay, you can give as much as you think is appropriate. But if they're not doing okay, you can hold back. So it's basically what we call a hold back trust. Take care of them, but hold some back to let them grow up for a while. So now we're going to talk about special needs trust. And thank you for your patience.
I want to hear.
But I hope that foundation and basic planning lets you put special needs trust into perspective. Before we get there, I want to say a couple of things. I see 24 chat questions. So Amber, you must be keeping busy. That's excellent. So Amber, you can unmute and let's give a, let's see if I can hear you.
Yeah.
There you go.
Yes. Hi, Michael.
Are people asking questions?
Yeah, we've got a lot of great questions in the chat.
Good.
Yeah, so I don't know if you want me to bring those up now.
No, I think we're going to get to special needs trust and then we'll jump into questions. I just want to see if there was any suggestions about, am I moving too fast or slow?
No, I think the timing, everyone said that I saw the timing and the flow is doing great. I think there's some questions about timing of conservatorships and costs and all that. So yeah.
Again, to emphasize people who may have joined a little bit later, what we're doing this morning is 2 sections. The first section is living trust and special needs trust. Part 2 is dedicated solely to conservatorships. So we isolate them. They're two separate concerns. So they're not all bound up into one. They're planning, but I like to tell people it's like Canada and the United States. They all look the same and talk the same language, but they're two totally different countries. So we isolate them so we can focus on what's needed for trust and special needs trust and what's needed for conservatorships. Because you may need both, you may only need one. We'll see. So we're going to finish with special needs trust, take some questions, take a short break, and jump back into conservatorships. Okay, Amber, thanks. And feel free to break in if something comes up that I need to fix.
Perfect.
Okay.
Thanks.
So moving forward to special needs trust, the main point I'd like to make for everybody is that when we're talking about, is that I need more tape.
I should put it on the stereo so I can hear better.
There you go.
I mean, that could do my Bluetooth, right?
Can everybody hear me okay?
Yes.
Okay. So here's the thing. Trusts are easy to create. They're easy to maintain. We're not talking about something that is very hard to do. It's much more difficult to do your taxes every year because most people will create a trust, put it on the shelf, and it'll sit there for 10, 15 years without any need for changing. So once you create one, it's not like a checkbook where you got to keep track of everything. It's very easy to maintain. We'll talk more about that a little bit later. So now let's talk about some additional planning tools, and then we'll get to special needs trust. We want to focus on parents. I tend to focus on the needs of parents. There are lots
Get Alan
of tools out there that parents can use for your children in terms of special education, therapy, occupational therapy, resources, regional center. But we feel that parents are neglected. So much emphasis is spent on the child with special needs, which is absolutely understandable. But oftentimes the parents' needs are also shunted aside. So we like to say, well, wait a minute, we have to take care of the parents, and not just so they can be a better caretaker for their child, so that they can solve their own problems and live the quality of life they want and have positive outcomes for themselves. If we do that, the chances of them producing positive outcomes for their children are greatly enhanced. So we like to start with the parents first, and we'll say, you guys can do everything you need for your child, but let's give you some solutions. And one of the solutions we need to talk to you about when we're talking about living trust planning and special needs trust are additional planning tools. What's your backup plan as a parent for yourself? Okay. The first thing everybody over 18 needs is a power of attorney for financial affairs. This is very simple. If you can't sign your tax return, or if you're selling your house and you have to leave the country and you've signed all the paperwork and there's a mistake, you can't fly back here and sign the paperwork again. Your spouse has no legal authority to sign your name to a document just because you're married to that person. Spouses, everybody over 18, we all need a general durable power of attorney. It's a simple document that says, I give you authority to execute my signature and handle my financial and legal matters for you if I'm not able to do it. If I'm out of the country or I'm disabled, then I give you permission to do it. And so that's a great tool. Of course, you only give that power to the people that you love and trust and have confidence in. And if you think they're going to steal your property, then don't name them as agent. They have no legal right to steal your property just by being your agent. But you would never appoint somebody with any doubt about that. So typically it's spouse, maybe an older child or a brother or sister. And these powers of attorney are changeable, amendable. So that takes care of the financial and legal part. The other power of attorney we want to talk about is an advanced healthcare directive. Now, if you're married in California and in federal law, you have authority to access your spouse's medical records and to make medical decisions for them if they can't do it. That works one time, but if you're single or if you're both hurt or sick, you don't have anybody that can step in and make decisions for you. So the solution to that is the California Advanced Healthcare Directive. And there's two components to the healthcare directive. You appoint somebody to make medical decisions and act as your agent for getting prescriptions, things like that, general medical care. That's called an agent for power healthcare decisions. And the other one is the what we call the pull the plug part, which says that if you don't want to be in life support, what's your wishes? And that's something that's very personal, but that's part of an advanced directive also. Everybody needs to do one of those also. The other planning tool you want to think about is a guardian designation for your minor child. If you have children under 18 and you die, the guardian would be the one that would take them to school, the doctor, and make sure they get a place to live and food to eat, be responsible for them. And you can designate a guardian part of the plan. You can't do it and make it legally enforceable. It would still have to go to court. But the judge would want to know, well, what did these parents want? Who did they want to be guardian? Oh, they wanted these people. They wanted June and Bob Smith to be guardian. Well, fine, we'll do that as long as June and Bob Smith agree to do it. So the court is looking for your guidance on that. And so it's a simple thing. It's not a big deal. You just have to think it through and say, where would our kids go live if they're under 18 if we died? And so that's guardian planning. So to review the basic planning, we've got wills, living trust, advanced healthcare directive, general durable power of attorney. You might as well do some memorial instructions, and you want to build an estate planning support team. We'll talk more about that later. Okay, so now let's talk about what we came here for, which is special needs trust planning. Thank you for allowing me to drink water. Okay. The main point I like to make at this stage of the workshop is that everything we've talked about up to now does not directly relate to special needs trust planning, but it's everything we talked about up to now is the foundation that is needed to be built by every family, regardless of whether you have a child with disabilities or not. Every family needs to do the steps we talked about earlier. And then we say, okay, what additional steps should we take as parents if we have a child with developmental disabilities? And yeah, there are additional steps, but it's very much like building a house. So instead of building a 3-bedroom house, we're going to build a 4-bedroom house. So we're going to add some special room, planning room, to deal with and provide solutions to all the challenges you face moving forward to make sure your child with disabilities will be okay in the long run after you're gone. So you're going to use your trust as the basic tool, and then we're going to build on that. Before we talk about special needs trust specifically, we want to talk about these questions, and I'm sure you all have them. You want to think about what's going to happen to my inheritance. Let's say I have a 12-year-old with level 3 autism who is nonverbal, who will never be able to manage their life on their own, who will always need support of others for their lifespan to age 80. What's that look like? What's the plan for that? How can we make sure that after we're gone, our son or daughter will have the highest quality of life possible and have the resources to meet their needs? That's what special needs trust planning is about. Not really a legal issue, but a life planning issue. And then the next question is, okay, if I leave money to support my child with autism, will that money disqualify my child from receiving public benefits such as SSI or Medi-Cal or housing benefits or transportation? And the answer is yes, unless it's done correctly. And that's what we're going to talk about. So you say, well, how can inheritance be protected for lifespan planning to make sure that for their lifetime, and also to protect that child from being disqualified? You're going to talk about, well, then we're going to need somebody who's going to manage that process when we're gone. So we're going to say, and then where will my child live? And how can I make sure that as my child lives, that these roles being assumed by different people may change because the people may come and go. I need a comprehensive plan for my child's well-being for their lifespan. So when we talk about the special needs trust, it's not just a simple tool. It encompasses all these things. And the special needs trust serves as the foundation for accomplishing all these goals. So the basics of special needs trust are this, that when you die and your child is receiving financial needs benefits such as SSI or Medi-Cal, meaning that get those benefits because they're disabled, but they can't have more than $2,000 in assets. If you leave money to them in a trust
That
with
make
the
it.
general provision says, I leave money, or if you don't have a trust, they will no longer qualify for the benefits because they're gonna have too much money. The inheritance you leave for them is gonna be considered an available resource. And SSI and Medi-Cal will say, well, you got too much money, you don't qualify, okay? So remember, SSI and Medi-Cal doesn't take your money. They just say your child is too rich, they don't qualify, come back when they're broke, and you don't ever want them to be broke. So the question is, how can we leave that money for them and let them continue to qualify for these benefits, which could be quite substantial over a lifetime? SSI and Medi-Cal both provide huge lifetime benefits. So we want to preserve those, right? We don't want those benefits to be cut off. So if your child qualifies for these public benefits, you want to make sure that you made a provision. Remember our trust, right? And the trust said that when you die, you give your money to your kids. But let's change the scenario a bit. Let's say the Baxter family has 2 kids, Jack and Julie. And Jack's neurotypical. So their trust says, when we die, our son's Jack 30, just give him his money. Fine, he can do what he wants with it. But Julie has level 3 autism. You know, she's never going to be able to manage her own money. So let's build a trust for her. And in my office and with Amber, we use what's called a standalone special needs trust. I mean, we draft a trust just for her. It says when the Baxter family dies, Julie's money goes into a separate trust, just all about her. And we appoint Uncle James as the trustee. And the rules of the trust are pretty simple. They say her inheritance can be used for anything that Julie needs for her health, happiness, support, education, team member, therapy, horse riding, computer, phone, renting, buying a house, buying a condo, anything that helps her life. The trustee is free to use that money, as long as that distribution or that purchase does not disqualify Julie from receiving government benefits. So people say, well, what can they spend it on? And I go, well, that list is pretty much endless. The important question is, what can the money not be used for? So remember, her trust money will be held in her special needs trust. Uncle James is going to hold the money, manage it, hire investment people, support Julie in her lifestyle, which she needs, while she continues to get SSI and Medi-Cal. Totally legal. We do this all the time. It's accepted. It's the way to go. And it only makes sense, because why should Julie receive less benefit than her brother James or Jack, right? He got all his money. She might as well get hers too, but we don't want her to be losing public benefits. So the special needs trust is a solution for that. The funds can be used for virtually anything at all: computer, movie, home, health aid, rent, anything they needed. It just can't be used. She can't get cash from it. That's about it these days. It used to be a longer list of not use the money for clothing, for food. The clothing thing is fine now. We have young individuals with developmental disabilities who are beneficiaries of trust, and buying clothing is a big deal for them. Clothing that fits them, eyeglasses that fit well. And so that's expensive, and Medi-Cal won't cover for a lot of that stuff. So a special needs trust can do all that. And when we say, is it allowed? What we need to understand is that Medi-Cal and SSI doesn't come into the home and ask for receipts and inspect the closet or the refrigerator and see where the money's going. It's none of their business. What SSI and Medi-Cal will do in an audit, they'll say, hey, look, Julie's been receiving SSI and Medi-Cal, and we see that she's got $500,000 in her trust, because they'll they'll see a copy of it because we legally have to give it to them after the parents die. We want to see the record. Let's bring in the checking account. And if they see, monthly distributions of $400 cash from an ATM machine, they're going to ask the trustee, where is that cash going? And if the cash is going to Julie, SSI is going to say, all right, she gets $400 a month cash, so we're going to reduce her SSI benefit by $400. And you owe us back pay from all the time the trust has been in existence. Because if you could give her $400 today, then you could have given her $400 3 years ago. So basically, SSI ends up disregarding the trust provisions and making it an available resource on their records. And they just say, we're going to stop paying SSI to Julie because she's got a $500,000 trust, and the trustee is using it in whatever fashion the trustee deems fit. So she doesn't need our money. She can live off her special needs trust. A properly administered and drafted special needs trust will prevent that from ever happening, because the trustee will be prohibited from giving cash to Julie ever on paper. And even if there's a mistake, the trust provisions say that was a mistake. And the trustee cannot use the money in any way that can cause SSI to disqualify Julie from receiving public benefits. So it's very important to understand, it's not anything to be nervous about. It's actually not hard to accomplish with good special needs planning. It's not a trick, and there's no inspectors that come around. It's just potentially an audit. So another thing, when we talk about special needs trust and what the money can be used for, that's the mechanical financial part, right? And the legal part. When we really have to say, yeah, but how is Uncle James going to know what to do for Julie? That's really important, right? Because we can draft legal documents all day long and put these provisions in them, and you die, and your son wakes up at age 27 with level 3 autism, and suddenly there's other people stepping in, and they have all the legal framework, but it's like, well, what do we do with him? Where does he go to day pro? What are his allergies? What's his food? And so it used to be we advised to people to do what's called a letter of intent. And I call that the old-fashioned way. You're supposed to write down all these things about your son or daughter that other people would need to know. It never works. I've never seen one work, Amber. You probably have never seen, people don't even do that. It's you can't accomplish it. It's just daunting. And as soon as you write all that stuff down, it's outdated anyway. And who wants to do that? So the exciting news is I created an app for that called Vest. I'm giving a little plug for our workshop next week called Vest. And we're going to focus on the replacement for the traditional special needs letter of intent. I know Mina sent out invites, so we want to encourage everybody here to sign up for next week because it's really exciting. We developed a easy to use special needs organizer that's going to save you time, and most importantly, it's going to let other people know what to do for your son or daughter. You'd be there. So we're very excited about that. We encourage you to attend next Saturday. So the special needs trust summary is that your special needs trust is going to protect your child's inheritance from being considered as an available resource. Your child is going to continue to qualify for government benefits, and your inheritance is going to be used to greatly enhance their quality of life through supplemental payments in addition to their public benefits. So that's the special needs component. And hopefully I've made it clear that it's not the only reason to do estate planning. It's part of planning you do for each other, for your loved ones, for your family. And special needs trust is actually a very rewarding part of that because there are absolute guaranteed solutions. Okay. We're going to talk about conservatorships at the next section. So for right now, we just like to remind people, beautiful Saturday morning, right? And people, they're probably already asking Amber, and if not, I'll ask you, Amber, when should I do all this? When's the right time to do planning? And the answer to that question is, just do it before you die, right? And I don't mean to be trite, but it's like, I don't know. And it really becomes a question of when's the right time to fit estate planning into your list of priorities. And today, it's a beautiful day. The sun's shining brightly, really nice and warm today. So we say, well, what are your priorities? we got to go on vacation this summer, and it takes more time and money to plan for your vacation and actually have a vacation than you ever will spend on your lifetime estate planning fees. Just one vacation, well in excess of what you'd spend in fees doing special needs trust planning and living trust planning. There's a lot of yard work to do. There you are, Amber. I know you're out there in the backyard today, right? You're shoveling dirt, putting bark in, and running to Home Depot 3 times because you keep forgetting the thing you need, right? We all do that. That's a priority. And then there's little Sparky, right? Little Sparky needs attention. The dog, the cat, whoever takes a lot of attention away. And probably if it's like our dog Penny, by the time we walk her, wash her, dry her, and all that, that's probably the same amount of time it would take for an initial consultation to get started on your trust planning. It's about it, an hour and a half, okay? So when you do all these things, we say fit in taking care of your family and your loved ones as part of your priorities. That's the right time to do estate planning. And it's going to give everything you have to whom you want and do it all at the lowest possible cost. And it's going to help you protect your loved ones as you venture forward in life. Okay. So now I want to say thank you for session 1. And look, that was just a little under an hour, not too bad. Conservatorships are going to go much quicker. But thank you again, everybody who joined.
Michael, there's a couple, before we get on to the break and the conservatorship section, there was just a couple of questions I thought maybe you would address to the whole group. I thought they might have some more people interested. One was, how do you find a trustee? Because you're looking for someone, maybe you don't have someone in your family that you know is the right person. So how do you find that, and how do you make that decision?
Yeah, we hear that question a lot, and it's one of those questions and planning challenges I talked about earlier, that when we do planning, we face these challenges. The first thing to know is that there always is a solution, because there has to be. You can't say there's a roadblock, so we can't do estate planning, because it's that roadblock that is going to cause the biggest problem. So to answer your question directly, when we have families who have maybe just one person is trustee or nobody close by, maybe their families or friends are in different countries, the question is going to be, who's going to be the trustee when we die? And so what we encourage families to do is to look into a professional fiduciary. There are people, and there are several of them right there in Placer County, who are professional fiduciaries. And a lot of parents are using professional fiduciaries as successor trustees. These are complete strangers, which is oftentimes the very person that you want to have involved in making sure your finances for your children are going to be squared away, because they're licensed, they're bonded, and they do it for a living. Okay, and they're heavily regulated. So a professional fiduciary is a tool, a solution we can use for families when you don't have somebody that you can use as a trustee here. There's a lot to it, but I have a lot of parents who have family members, brothers, sisters, adult children, and they choose to use professional fiduciaries anyway, because they love their children, but they don't have confidence that their children would be successful trustees, or they don't want to create conflict between the children by putting one in charge. So they'll designate a professional fiduciary. There's no cost to doing it. You just meet the fiduciary. I like this person. You plug their name in, and then give them authority to replace themselves or do alternates. So bottom line, a professional fiduciary is a suitable alternative for doing trust planning for families who don't have somebody close by to do that job.
And one of the other questions that came up from a couple of people was using employer-sponsored discount plans for trust.
Yeah, that's a question we see a lot too.
Mm-hmm.
And there are many employer-sponsored legal services plans that give you the authority to do trust planning. And I say investigate them, they're fine if they work well. And if you find a lawyer that you like and look them in the eye and feel comfortable that they know what they're doing, you can hire them and get the benefit. What I talk about though to people is, I mean, I don't do that. I don't work with those employer sponsored programs. It's just not something we do. When it comes to special needs planning, be very cautious, and we encourage people to be aware of the what we call the sometimes special needs lawyer, the general practitioner who is excellent at doing living trust planning, done it a lot. But when it comes to special needs planning, they don't have a real depth of knowledge about your world and the challenges you face and the solutions that can be implemented, because they don't do it very often. So that's the decision I think you'll reach most often with the employer sponsored plans is, how many special needs trusts have you drafted would be a great question to ask that attorney. And then you want to get more than one consultation. You want to consult with someone like me or Amber, who's done this a lot and a ton, and then consult with your employer sponsored attorney and then make your decision. And sometimes the employer's plan attorney is just excellent, but that's really a personal choice for you.
Okay, thank you.
Right. So that was it. Well, then I appreciate you fielding 51 chat questions as we go through. So,
Well, oh, Michael, one other question I
Yeah.
will just say, I think there was a little confusion. Someone said, should I think just understanding the difference between the conservatorship process and the trust planning process. I think there was a little bit of questions of, do I need to do it all at the same time?
okay,
So
well, that's good. Then that's a good segue to our next part. And so, again, I come up with these corny analogies, and I'm the dad joke guy. I just come up with corny stuff, and my wife goes, "That's corny." I go, "Well, good. That means it's simple." But think of living trust and special needs plus trust planning as the United States, and think of conservatorships as Canada. And when you drive over the line from the United States to Canada, it all looks the same, and we speak the same language, and can be, well, where am I? Am I in the US or Canada? But I want you to think about the two as two totally separate countries and jurisdictions. That's the easiest way. You do living trust planning for the benefit of leaving an organized estate outside of probate for the benefit of your spouse and your children through living trust and special needs trust planning. You may never need a conservatorship for your child. You may never need one. And we'll talk about that in a few minutes, but you would still need to do the living trust and special needs trust planning. Conservatorships, as we'll talk about in a minute, aren't something you do until your child reaches age 18 or just shortly before that. And that's a legal process that deals with your child's legal rights. And how will your child be able to enjoy the benefits of being a legal adult when they don't have the capacity to understand their own rights? So a conservatorship will transfer their rights to you as the parents, so you can continue to make sure they have a quality of life, that they're protected by exercising their rights for them. We do conservatorships and people don't do trust. I just finished a conservatorship, and now 3 years later, the parents came back and says, okay, we want to do our trust planning now. So the two aren't dependent upon each other, and they're not directly connected, except that it comes out of love and care for your family. So you can do a living trust now and do a conservatorship when your child turns 18. You can put off the trust if you wish, do the conservatorship when your child turns 18, and then years later or months later, come back and do a trust. The two aren't dependent upon each other. And I hopefully that's clear. We'll talk more about that.
yeah, thanks, Michael. And the last question I'll just broach is there's lots of questions about cost and what does it cost to do special needs planning?
Right. Well, I only can tell you what my office charges, and Amber and I, like I said, we team up on these things. You're going to look at doing living trust planning. I don't like to say special needs trust planning because that makes it sound like it's one product. Living trust planning, it includes special needs trust planning. When I started doing this 20 years ago for my first living trust with special needs trust, I was charging like $1,200. And the family asked me, well, how much extra for a special needs trust? And I thought about it for a minute. I go, there's no extra. It's just your family. So you got 3 kids, one with autism. Why should you pay more than the other family? That doesn't sound right to me. So for me, I've never charged more for a living trust, which includes special needs trust planning for a family member. Other lawyers might, I'm not sure. But your typical living trust fees, if you went to a living trust lawyer in Sacramento right now, the fee will be $2,500 to $3,500 for a married couple with kids. If you own one house, if you own more than one house, it'll be a little bit more. But that's a range of fees for living trust planning. And in my office, I don't add on for special needs trust planning, even though it's a totally not distinct, but it's more legal work and planning. But some lawyers I know do, I'm not sure, but the general range, Amber, is that what you see out there for living trust planning? $2,500 to $3,500?
Yes, I think I would say it probably starts at 35 now that I've seen it recently.
Yeah, recently. And look, like
Yeah, I would say recently it's, 25 is kind of the bottom
Yeah.
but starting more at 35.
35, yeah, and like everything else, legal fees have finally gone up. I mean, I pulled out a bill from 12 years ago that billed a client. It was like $3,000. And so even today, charging $3,000, there's very little inflation, but it is more than it was traditionally by maybe $500 or $750. So a living trust planning, remember, it's like a one-time fee. After you do a living trust and do it well, it's not, you don't need to review it every year and all that. Typically it's 10 to 15 years before people call me and want to make a change, which means I don't have many changes coming over the next 10 to 15 years.
Mhm.
So, and conservatorships, we'll talk about those fees in a few minutes, okay?
All right,
All
thanks.
right. So we want to take 5, everybody? We're still good. I'm assuming everybody says it's okay to take a 5-minute break. It's, according to my clock, it's 10:40. I don't know what